Hi, my name is Zoe Ji and I'm an associate attorney at Alexandra Law Firm and Associates. I focus primarily on extraordinary ability, employment-based, and business immigration matters. I wanted to share a recent case that really pushed us as a legal team and ultimately became one of the most rewarding wins I've ever had. We were approached by a client who had entered the US on a B2 visa with their family. While they were here, they were offered an opportunity that aligned with their work as an artist, and they wanted to pursue an O1B visa. The timing was very tight. Their lawful status was about to expire. They needed to change from B2 to O1B and O3s, all from within the US. On top of the timeline, the case was complicated because the client's profile didn't fit squarely within traditional O1B parameters. They had a significant teaching background and accolades that could arguably fall under the O1A visa, which uses a completely different set of criteria. So the challenge was, how do we clearly frame this as an O1B case while still accounting for the evidence that doesn't look traditionally performative? We spent days combing through the materials, pulling through a cohesive narrative and all the supporting evidence. We drafted a comprehensive petition letter that clearly mapped each piece of the evidence to the criteria, all supported by the client's extraordinary ability in the arts. We also proactively addressed the intersection between their work as an artist and an educator, making the case that in their field, instruction isn't separate from artistic distinction, it was a part of it. After filing, we got an RFE. It was 16 pages long and easily one of the most detailed and aggressively skeptical RFEs I've ever seen in any O1 case. USCIS questioned whether our client's teaching background aligned with the claimed field of artistry. They argued that teaching and creating art are distinct. They challenged the national significance of the awards, the credibility of the expert letters, the media recognition, critical role, commercial success. USCIS questioned and challenged absolutely everything. At that point, we didn't really have a wealth of new documents to add, so we had to rely on legal analysis, precedent, and the reframing of our existing record. I drafted a 25-page single-spaced RFE response. It addressed every issue head-on. We cited federal court decisions which criticized USCIS for failing to consider the totality of evidence. We drew from AAO decisions to support the argument that teaching roles can and often do reflect artistic leadership in fields like this beneficiary. We included expert commentary on the cultural norms of master-apprentice teachings in this specific art field, and we walked USCIS through the historical expectation that established artists are expected to teach. For awards, we dug into each one again, providing evidence of the issuing body's reputation, selection criteria, even though we had already initially submitted this. We contextualized the judging invitations a bit more and the publications as comparable evidence for O1Bs, and we had to reinforce the idea that some art forms just operate outside usual media visibility, but they still meet the standard of extraordinary ability when properly understood. 15 days later, after we submitted our RFE response, we got an approval. It was a huge relief, of course, for this client and their family, but even personally, for all of us at the firm. We all poured our entire hearts into this case. I know I poured my entire heart into that brief because I knew that response was our one chance to get it right, and it worked. The client and their family are now safely and lawfully in the US under O1 and O3 status, and we all couldn't be happier. This case reminded me that effective legal advocacy isn't just about evidence. It's about interpretation, precedent, and persuasion. Sometimes it's about making space within the law for careers that don't follow a traditional path, but still clearly meet the extraordinary ability standard. Helping this family secure their future reminded me why I do this work, because every detail matters and every case is worth fighting for.